A federal judge just issued a ruling at 11:47 p.m. that fundamentally rewrote every assumption about Trump's legal strategy and timeline. We're not talking about a routine scheduling order or a minor procedural decision that gets filed after business hours. This is a comprehensive 89-page opinion issued in the middle of the night that strips away Trump's primary legal defenses, accelerates trial dates by months, and creates immediate consequences that Trump's legal team has no procedural mechanism to delay or appeal. When a federal judge works past midnight to issue a ruling that explicitly rejects every major argument Trump's attorneys have made, denies every motion for delay they filed, and sets a trial date just 11 weeks away with language stating that no further continuances will be granted under any circumstances, the legal walls have closed in completely. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what did this midnight ruling actually do? On March 15th at 11:47 p.m., U.S. District Judge Tanya Chutkan issued her decision on Trump's motions to dismiss the election interference case, his request to delay the trial, and his claims of presidential immunity. In a sweeping opinion that legal scholars are calling one of the most thorough rejections of presidential immunity claims ever written, Judge Chutkan denied every single motion Trump filed, ruled that his claims of immunity have no legal merit, and set a firm trial date of June 3rd with explicit language that the trial will proceed regardless of Trump's political calendar or campaign schedule. The ruling doesn't just reject Trump's arguments, it systematically dismantles them with extensive citations to constitutional text, Supreme Court precedent, and historical evidence, creating a legal record so comprehensive that appellate courts will have substantial grounds to affirm rather than reverse. This isn't a ruling Trump can easily appeal his way out of. This is a judicial roadmap that makes conviction significantly more likely. Here's what's been building to this extraordinary midnight ruling. Trump's legal team has spent months filing motion after motion, seeking to dismiss the charges, delay the trial, and establish that Trump has absolute immunity from prosecution for any actions taken while president. Each motion made increasingly aggressive claims about presidential power, arguing that presidents cannot be prosecuted for official acts, even if those acts violate criminal law, that Trump's attempts to overturn the 2020 election were within his official duties as president, and that prosecuting him would violate the separation of powers. Judge Chutkan has rejected these arguments in previous orders, but Trump's attorneys kept filing variations of the same motions with slightly different legal theories, a strategy designed to create delay through endless procedural litigation. The midnight ruling represents Judge Chutkan's comprehensive response to the entire universe of Trump's legal arguments. Rather than addressing each motion separately and allowing Trump to file new variations, she issued one sweeping opinion that addresses every conceivable immunity and dismissal argument Trump could raise, effectively closing off any further attempts to delay through procedural motions. According to legal experts who reviewed the ruling, Judge Chutkan has created what lawyers call law of the case, meaning her determinations on these issues are final for purposes of this trial and cannot be relitigated through additional motions. Smash that like button if this is making sense so far. Here's where the ruling becomes devastating for Trump's defense strategy. Judge Chutkan doesn't just say Trump's immunity arguments are wrong. She explains in meticulous detail why they're wrong, using Trump's own actions and statements to demonstrate that his conduct falls outside any conceivable definition of official presidential duties. The opinion quotes extensively from Trump's own social media posts, speeches, and communications, showing that he was acting in his capacity as a candidate seeking to remain in power, not as a president executing the duties of his office. When the judge uses your own words to prove you were acting for personal political benefit rather than official presidential duties, your immunity defense evaporates. What happened in the hours after the midnight ruling reveals just how catastrophic this decision is for Trump's timeline and strategy. Trump's legal team had been operating under the assumption that they could delay the trial until after the 2024 election through endless pretrial motions and appeals. The midnight ruling destroys that strategy by setting a June 3rd trial date and explicitly stating that the court will not grant any continuances based on Trump's campaign schedule, political events, or requests for additional time to prepare. At 7:23 a.m. on March 16th, just hours after the ruling was issued, Trump's attorneys filed an emergency motion for reconsideration, arguing that the June 3rd trial date doesn't give them adequate time to prepare their defense. Judge Chutkan denied that motion at 9:14 a.m. the same morning in a brief two-page order stating that Trump has had months to prepare, that his legal team's delay tactics have already consumed substantial court time, and that the trial date is final. Drop a comment right now if you saw this coming. I read every single one. The most significant moment came at 2:37 p.m. on March 16th when Trump's attorneys filed a notice of appeal to the D.C. Circuit Court of Appeals, seeking to block the trial date and challenge Judge Chutkan's immunity rulings. But here's the procedural reality that makes even the appeal ineffective. Under federal rules, filing an appeal does not automatically stay the trial court proceedings. Trump would need the appeals court to issue an emergency stay blocking the trial while the appeal is heard, and appellate courts rarely grant such stays. Legal experts reviewing the midnight ruling noted that Judge Chutkan wrote her opinion with appeals in mind, creating an extensive factual and legal record that gives appellate courts every reason to affirm her decisions quickly and deny any request to delay the trial. This isn't the first time Trump has faced adverse court rulings, but the midnight decision has several elements that make it uniquely problematic for his legal position. In the New York criminal case, Trump successfully delayed the trial multiple times through procedural motions and changes in legal counsel. In the classified documents case, the Trump-appointed judge has been sympathetic to defense delay requests. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. Judge Chutkan's midnight ruling eliminates the playbook Trump has used successfully in other cases by addressing every possible immunity and delay argument in one comprehensive opinion. She's prevented Trump from filing endless variations of the same motions. By setting a firm trial date with explicit language that no further continuances will be granted, she's removed the possibility of delay through procedural tactics. By creating an extensive legal record supporting her rulings, she's made successful appeals significantly less likely. The pattern is clear. When judges recognize that a defendant is using procedural motions primarily to delay rather than to raise legitimate legal issues, and when judges issue comprehensive rulings that foreclose further litigation of the same arguments, defendants lose the ability to control the timeline and must face trial on the prosecution's schedule. So what specific legal conclusions in the midnight ruling are most damaging to Trump's defense? Judge Chutkan's opinion makes several holdings that fundamentally undermine Trump's core legal strategy. First, she rules that the Supreme Court's Nixon cases and Clinton v. Jones established that presidents have no immunity from criminal prosecution for unofficial acts, and that Trump's attempts to overturn the 2020 election were unofficial acts taken in his capacity as a candidate, not official acts taken in his capacity as president. Second, she holds that even if some of Trump's actions could be characterized as official, the criminal conduct charged in the indictment, specifically the conspiracy to defraud the United States and obstruction of Congress, falls outside any immunity because such conduct violates the president's constitutional duty to faithfully execute the laws. Third, and most devastatingly, she finds that Trump's own statements and actions demonstrate he was motivated by personal political interests rather than official duties, citing Trump's own words acknowledging he lost the election but choosing to claim fraud anyway. Don't go anywhere. The most explosive part is coming next. The ruling includes a section analyzing Trump's state of mind based on contemporaneous evidence, finding that Trump knew he lost the election, knew his fraud claims were false, and proceeded with schemes to overturn the results anyway. That factual finding, if upheld on appeal, essentially establishes the criminal intent element of the charges before trial even begins. This puts Trump in extraordinarily difficult legal jeopardy. On one side, he faces a trial in just 11 weeks on charges that carry potential prison sentences totaling decades. The midnight ruling has eliminated his ability to delay that trial through procedural motions or immunity claims. On the other side, any appeal he files faces an uphill battle because Judge Chutkan has created such a comprehensive legal record supporting her rulings that appellate courts have substantial grounds to affirm quickly. And here's the timeline reality that makes this truly catastrophic. A trial starting June 3rd will likely conclude by late July or early August. If Trump is convicted, sentencing typically occurs 60 to 90 days after conviction, meaning Trump could be a convicted felon facing prison time by October 2024, just weeks before the general election. The political implications of a conviction that close to the election are staggering. Legal and constitutional scholars are calling Judge Chutkan's midnight ruling one of the most significant judicial opinions on presidential accountability ever written. Lawrence Tribe, Harvard law professor, told CNN that Judge Chutkan has produced a masterpiece of constitutional analysis that will be studied for generations. The opinion systematically dismantles every argument for presidential immunity from criminal accountability, using constitutional text, original understanding, and historical practice to demonstrate that presidents were never intended to be above the law. This ruling will make it significantly harder for any future president to claim immunity from prosecution. Neil Katyal, former acting Solicitor General, added that the midnight ruling's comprehensive analysis creates a strong foundation for quick affirmance on appeal. Judge Chutkan didn't just rule against Trump, she anticipated and addressed every argument he might raise on appeal. That kind of thorough opinion typically leads to quick appellate decisions because the appeals court doesn't need to develop the legal analysis from scratch. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even some conservative legal scholars acknowledge the strength of Judge Chutkan's legal reasoning. J. Michael Luttig, former federal appellate judge, wrote that while he has concerns about prosecuting former presidents, Judge Chutkan's legal analysis is sound, and her conclusions about the limits of presidential immunity are consistent with constitutional structure and Supreme Court precedent. The opinion demonstrates that prosecuting a former president for criminal conduct is not only permissible, but necessary to maintain the rule of law. The immediate impact is creating panic in Trump's legal and political circles. Trump's legal team now has just 11 weeks to prepare for a trial they expected to delay until after the election. The compressed timeline means they cannot pursue their usual strategy of endless pretrial litigation. They must prepare witnesses, finalize defense strategy, and get ready for a trial that could result in conviction and decades in prison. Second, the political calendar has fundamentally shifted. Republicans planning to nominate Trump must now reckon with the reality that their candidate will be on trial for election subversion during the heart of the campaign season and could be convicted before voters go to the polls. The timing creates enormous political complications. Finally, this ruling establishes a precedent that presidential immunity has real limits and that former presidents can be prosecuted for criminal conduct even if that conduct involved official government processes. The legal landscape for presidential accountability has permanently changed. Drop a comment below with your thoughts. But beyond the legal crisis for Trump, this is about whether former presidents can attempt to overturn elections through criminal schemes and claim immunity from prosecution. Judge Chutkan's ruling establishes definitively that they cannot, that presidential power has limits, and that criminal conduct remains criminal regardless of who committed it. If appellate courts uphold this ruling, it creates a framework for presidential accountability that will govern for generations. Republicans are in turmoil. Party officials must explain why their candidate will be on trial for election subversion during the campaign. Trump must confront that his delay strategy has been eliminated by a judge who issued a comprehensive ruling specifically to prevent further procedural obstruction. Trump's response has been characteristically defiant but legally desperate. He's attacked Judge Chutkan as biased, claimed the midnight ruling proves the case is politically motivated, and insisted he'll be vindicated on appeal. But legal experts note that attacking the judge doesn't change the legal analysis in her opinion. Claiming bias doesn't address the constitutional arguments she made, and promising vindication on appeal doesn't alter the June 3rd trial date that remains in effect while any appeal proceeds. Stay with me because what comes next will completely change how you see this. Here's what makes the midnight ruling so significant. Judge Chutkan didn't just reject Trump's arguments in a routine order. She worked past midnight to issue an 89-page opinion that comprehensively addresses every conceivable legal theory Trump could use to delay or dismiss the case, creating a legal record so thorough that appellate courts will have substantial grounds for quick affirmance. The timing, the length, and the comprehensiveness all signal a judge determined to move this case to trial without further delay. This goes far beyond whether Trump faces conviction in this particular case. It's about whether the legal system can hold former presidents accountable for criminal conduct or whether presidential power effectively grants immunity from the rule of law. Judge Chutkan's midnight ruling establishes that presidents are not above the law, that criminal conduct remains prosecutable even when committed by someone who once held the highest office, and that courts will not allow endless procedural delays when defendants use the legal system to obstruct rather than to pursue legitimate defenses. The stakes are existential for the rule of law itself. If this blows your mind, hit that like button right now. Here's the situation. A federal judge issued an 89-page ruling at 11:47 p.m. denying every Trump motion, rejecting all immunity claims, and setting a trial date 11 weeks away. Trump's legal team filed emergency motions that were denied within hours. The trial will proceed on June 3rd, regardless of Trump's campaign schedule. The ruling creates a comprehensive legal record that makes successful appeals unlikely. Trump faces trial during the campaign and potential conviction before the election. His delay strategy has been eliminated by a judge who worked past midnight specifically to foreclose further procedural obstruction. Keep watching because this case is accelerating toward trial. Trump's appeals will be heard and decided quickly. Jury selection will begin June 3rd. The trial will proceed through the summer, and political observers are watching to see whether Trump can campaign while on trial for attempting to overturn the election he lost. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. Judge Chutkan has issued a midnight ruling that rewrites Trump's legal reality. His immunity defenses have been rejected comprehensively. His delay tactics have been foreclosed. His trial date is set for June 3rd with no possibility of continuance. His appeals face an uphill battle against a thorough judicial opinion designed for quick affirmance. This isn't a temporary setback that better legal strategy can overcome. This is a comprehensive judicial dismantling of Trump's entire legal defense that puts him on an unavoidable path to trial during the campaign season with potential conviction before the election. Either the legal system convicts Trump for attempting to overturn an election, establishing that former presidents face accountability for criminal conduct, or Trump is acquitted and establishes that presidential power grants effective immunity from prosecution. What happens over the next 11 weeks will determine whether American democracy has a functional system of accountability for presidential misconduct. The midnight ruling is issued. The trial date is set. The legal defenses are dismantled. Now we wait to see if the rule of law applies when a former president faces criminal trial for attempting to subvert an election. The stakes for American democracy have never been higher. The judicial opinion has never been more comprehensive, and the legal reality has never been more definitively rewritten. Pause for a second and hit that like button if you're finding value in this coverage of the most significant midnight ruling in modern American legal history.